Afternoon, everyone. My name is Peter Neufeld. I'm a partner at the firm Wagner Sidlowski and the co-chair for this Lunch and Learn series on strategies, advice, and the elderly, along with Brad Phillips, who is also a partner at Wagner Sidlowski. First off, particularly because it's Truth and Reconciliation Day today, I'd like to do a land acknowledgement. We acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, the Wendat peoples, and that this land is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. On this National Day for Truth and Reconciliation, we honor the enduring presence and resilience of Indigenous peoples on this land and commit to learning, listening, and supporting reconciliation in meaningful ways. The subtopic that we are speaking about today is about the settlements involving the Incapable. A paper was prepared today by Jake Pallas and Alex Prokop in advance of today's seminar on this topic, and a link to that paper can be found in the Zoom chat. The certificate of attendance will be posted in the chat momentarily for you to download. The seminar has been approved by LawPro for the risk management credit, and it is eligible for a $50 credit claim. So please refer to that document also posted in the chat. No reason not to claim that credit. Thank you to our sponsors. As always, you are the reason that this event is complimentary. Particularly thank you to Scotia Wealth Management, the B'nai B'rith, Concentra Trust, Weir Folds, Donovan Kochman, and Torkin Mains. As always, a few housekeeping notes. Please have your microphones muted at all times unless you are asking questions at the end of the presentation, after which we ask that you mute yourself again. Please also note that this seminar is being recorded. We have three excellent presenters today, Alex Prokop, Jake Pallas, and Brendan Donovan. Alex Prokop is a partner at Perez Prokop Lineveer LLP. His practice is concentrated in capacity, guardianship, power of attorney, and estate matters. He will be joined by Brendan Donovan, who is a partner at Donovan Kochman LLP, where Brendan focuses on estates and trust litigation. Both Brendan and Alex are frequent speakers at estate and capacity litigation seminars and events, and both have a reputable mediation practice. And we're delighted to have them here with us today. And they will be joined by Jake Pallas, who is an associate at Wagner Sidlowski, practicing in the estate and commercial litigation groups, and who has graciously prepared a paper with Alex for today's presentation. Before I get into the crux of the seminar, I'm going to have Joel Sermon from the B'nai B'rith have a short discussion. And I also note that if you've enjoyed this seminar series so far, we ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't already. The link for doing that will be in the chat. So Joel, you have the floor. Go ahead.
Thank you, Peter, and thank you very much, everybody, for having me. My name's Joel Sermon. I'm B'nai B'rith's Operations Director. I'm standing in for Cheryl Landy today, who's unfortunately ill. So it's a pleasure to be with you. For nearly 2 decades, nearly 20 years, B'nai B'rith has proudly partnered with Wagner Sidlowski's CLE programs. We're really grateful for our long-standing relationship with your firm, and especially the meaningful work you continue to do for the legal community. As many of you know, B'nai B'rith is the country's oldest human rights organization. We are committed to combating racism and hatred, advocating for the Jewish community, and supporting some of Canada's most vulnerable populations, including the elderly, the isolated, and those living in poverty. In fact, this year we're celebrating our 150th anniversary. In previous visits and previous discussions Cheryl's had with you, I know that she's discussed our food bank, she's discussed our affordable housing program for seniors, and also our clothing pop-up shop that we hold over the past couple of weeks. Today, I want to share another program that we put on. It's one that doesn't grab headlines, but quietly really does change lives on a weekly basis. And that's our men's club. The men's club began really just a few older men, many of them widowers or retirees, gathering for a bagel and a schmear and a coffee and some conversation. And what started really as a casual morning meetup soon became a lifeline for men who had lost a spouse or left the workforce or found themselves just feeling isolated. Quite quickly, it grew into a structured program, and today the men's club meets regularly for a meal, a conversation, and really the crux of it is the camaraderie. Guest speakers come in and talk about all sorts of different topics: health, retirement, culture, current affairs, and we also plan outings for the men to museums, to the theaters, etc. Critically, it's a social circle, but for many of them, it's more than that. It's a reason to get up in the morning and feel a part of something. The men's club has become so popular that recently we've actually had a younger cohort coming to experience the camaraderie of men sitting together. I often say, women socialize looking at each other, and men socialize looking in the same direction. It gives the men a chance to sit down, look at a speaker and socialize and get to know each other. The program was pretty simple at the start: a room, a meal, some dedicated volunteers, but the impact really has been profound. And we know that isolation is a serious health risk for seniors, especially for older men. And the men's club counters that by creating a safe and welcoming space where laughter, stories, and even, quiet support takes place. At B'nai B'rith, one of our mottos is that community means connection. And just like our food bank that Cheryl discussed with you provides nourishment to over 130 families every week, and our pop-up store that she spoke about last time provides free clothing. This past weekend, it was over 400 people to restore their dignity. The men's club also ensures that no one feels forgotten and that they've always got a purpose and somewhere to go. So that's just a brief sort of overview of the men's club. And really, I want to thank you again for welcoming B'nai B'rith here today and for welcoming me and for your continued support of B'nai B'rith Canada. And I look forward to either myself or Cheryl sharing more stories in the months ahead. Like Peter mentioned, if you'd like to help us continue any of our work, please visit bnaibrith.ca/donate. That's BNAIBRITH.ca/donate. Your generosity really helps us in providing not just clothing, but compassion and community and hope. And I just want to thank everybody for the time and for standing with us and for the support. Thanks so much.
That's lovely, Joel. Thank you very much for that. Okay, we're going to start with the substance of the seminar now. Again, this topic is on settlements involving the incapable. We're going to have Jake Pallas start us off. He'll be followed by Alex Prokop and then Brendan Donovan. All right, Jake, take it away.
Hey everyone. So my name is Jake Pallas, and as Peter mentioned, I'm an associate at Wagner Sadlovsky LLP. My goal in the next 10 minutes is to answer three plain English questions. What is a settlement approval motion? Why do we need one? And when is it required? I'll keep the focus on purpose and principles so the discussion is useful across all different kinds of files and practice areas. After I finish, Alex will speak about the roles of the litigation guardian and Section 3 counsel, and Brendan will close with drafting and procedure generally. So, what is a settlement approval motion? A settlement approval motion is a judicial safeguard. When a party is a person under a disability, a settlement does not bind anyone until a judge approves it. The court's task on such a motion is not to rehear the case. It is to decide on the record presented whether the proposed compromise is in the best interest of the person under disability at that specific point in time. In other words, the approval hearing is a checkpoint designed to protect the person, not a miniature trial or a retrial. The question really is whether the compromise is better for the individual than continuing the litigation, given the risks, the evidence, and the plan for what happens next. It is equally important, in my view, to be clear about what an approval is not. Approval is not what creates the contract or negotiated terms between the parties. Counsel can negotiate and reduce terms to minutes of settlements. In other words, the bargain itself may be negotiated as between the lawyers. However, none of the settlement steps that implement the bargain should occur until the court has approved it. So, in other words, there should be no exchange of releases, no payment of funds, no consent judgment, and no dismissal of the action before the settlement itself is approved by the court. This approach preserves the protective purpose of the rule and why we actually have settlement approval motions, and it avoids prejudicing the person prior to the approval itself. So before the court is asked to decide the best interest on the written record, counsel is required to put forth materials. In practice, there's four elements that do the work. So first, essentially, there should be a candid affidavit from the decision maker on the person's side, often a litigation guardian, explaining why the compromise serves the person's interests. Second, there should be an affidavit from counsel that addresses the merits and risks directly. Third, the materials should include clear and complete minutes. And fourth, there should be a workable plan explaining how funds operate. Before turning to why and when, it is helpful to define what counts as a person under disability and be precise about incapacity. So, under the Ontario's Substitutions Decision Act, an adult is incapable of managing property if the adult is not able to understand information relevant to making decisions in the management of that property, or is not able to appreciate the reasonably foreseeable consequences of making or not making such decisions. The Act uses the same structure for personal care decisions. Capacity is an issue-specific and decision-specific assessment. A person may be capable rather, to give valid instructions generally. However, for the purposes of settlement approval motions, the question with capacity is respect to understanding the settlement itself. And it treats the person under disability within the definition under the SDA. With those definitions in place, it becomes easier to explain why we require approval. The first and most important reason, which I alluded to earlier, is the protection of the person. Where an individual cannot, in law, make the settlement decision, ordinary bargaining dynamics cannot be relied on. In other words, approval centers around the person's needs, their risks, and so far as they can identify those risks. It forces counsel to address before the court the potential liability, the limitations, and the issues that affect that person individually. It also obliges a counsel rather, to show how the proceeds will be used in the settlement to advance that individual person's interests. One of the other key reasons we have approval settlement motions is transparency and dignity. So our system is presumptively open. At the same time, approval motions often involve sensitive health information, private financial details, and candid litigation risk. A balanced approach is generally implemented by the court. In practice, that means drafting affidavits with public filings in mind, using targeted redactions or anonymization for issues that cannot truly be public. Sealing orders are treated as exceptional, and the court can conduct a rigorous best interest review of what's really important. Having described what approval is and why it exists, I will turn to when it is required. The starting point is simple. If at the time of the settlement is to be approved, the person falls within the definition of a person under disability, court approval is required before the settlement can be implemented. Three recurring scenarios can be illustrated to show how this plays out. The first is the obvious case in which an active party is a minor or incapable person. The second is the case in which there are reasonable grounds to doubt capacity in understanding the settlement decision. And the third scenario arises when a proposed settlement would impact an incapable person's funds, waive their rights, or materially affect their care. There are also two limited situations in which approval motions may not be required, and I think it's useful to identify those as well. The first is where the adult is capable with respect to the settlement decision at the time the bargain is concluded and presented. In that event, there's no need for a safeguard, and it doesn't apply. However, it remains good practice to create a clear record of capacity to show, if later impugned, that the person was in fact capable. The second is a narrow category of guardianship only. matters. If the proceeding is confined to relief under the SDA and the court is able to implement minutes by judgment, the court may proceed without a formal Rule 7 approval motion when those certain conditions are met. In practical terms, that requires current and reliable capacity evidence. This would be an exceptional circumstance and depends on a careful record and careful drafting. So, a recurrent practical question is what happens if the person under disability dies before approval hearing? We'll get into this in more depth a little later, but at a high level, the answer follows from the point I made earlier, which is approval is a condition of implementation, not the source of the contract formation. So an estate may seek to enforce the bargain after the impugned capacity person has passed away, and the court has the ability to address timing and various problems. So in other words, the court does have the ability to approve a settlement rather, after the fact. So those are the three answers to the three questions I set out at the outset. At a high level, again, a settlement approval motion is a best interest checkpoint supported by evidence and a comprehensive record. The court has essentially acknowledged we needed to protect the person, to supervise implementation and legal fees, and to balance openness with dignity. It is required when a settlement affects a minor or an adult who is incapable with respect to that settlement decision, and whenever prudence essentially requires judicial oversight of a vulnerable interest. So with that foundation in place, I'll now turn to Alex, who will get more into the meat of the issues.
Yeah, thanks so much, Jake. And I want to note at the outset that my name is on this paper first, but this is really Jake's show, that paper, and it's really comprehensive. We don't have enough time to get into everything that's in it, so I do encourage everyone to take a read through the paper. It's 14 pages long. It's pretty good. So, when we are dealing with settlements that involve incapable or potentially incapable people, I want everyone to leave with a few things, but most importantly, turn your mind to these issues really early on in your litigation, because if you don't, it can really trip you up later. Really, it should be one of the first things you think of, because Rule 7.03 sub 5 says you can't do any step in a proceeding after serving the originating process without an LG being appointed or a litigation guardian being appointed for a party under disability. So, from there, the rules have requirements that sort of get triggered by a party being under disability in all sorts of places. Basically, any exit ramp to your litigation, like judges approving a judgment, noting somebody in default, settlement approval, as we're talking about today, discontinuance of an action, abandonment of an application, and payments that are to be made to a party under disability have to be paid into court unless the court orders otherwise. So basically, you're going to have to confront this issue. And if it's not your client, if it's another party, it can get really tricky if you're unsure that that person is under disability. How might you be sure that the person is under disability? Well, somebody could apply to be a litigation guardian, and you can presume that they are under disability. There may be a declaration of incapacity and a guardianship order or some previous power of attorney litigation order. Those are ways to be absolutely sure. Somebody may hand over a capacity assessment on capacity in a realm of decision making that relates to an issue in dispute in your litigation. You can be pretty sure with that. But there are a lot of situations where you're going to encounter where it's just not clear if one of the other parties is. And as usual, the rules say, party under disability, turn right, capable, everybody else is capable, turn left. But the rules don't really help us a lot with a person who may be incapable. So, we can start our analysis with the presumption of capacity. So the SDA, the Substitute Decisions Act, says everybody's presumed capable of entering into a contract. There's other presumptions out there about managing property more generally and about care decisions. They kind of all start the same way with presumption of capacity, unless there are reasonable grounds to believe the person is incapable, which is clear as mud in a lot of cases. And it gives you a lot of kind of room to debate if you're just not sure, do I have reasonable grounds to believe the person's incapable? Um, so, I think it's pretty obvious what we might look at for reasonable grounds. So I'm not going to get into that, but I wanted to flag a couple other things we might consider um, when we're trying to determine what do we do about a party, another party who may be incapable. So you have to know your issues, your legal issues, and what they impact, because under the rules, your incapacity has to relate to an issue in the proceeding. So, send you back to your originating process and look at all the relief you're asking for, first of all. That's going to help you analyze the incapacity and need for a litigation guardian potentially. But drilling down a little deeper into that, when you're thinking about what settlement options you might be considering, like what might resolve things for your client, um, those might not be all the things in your pleading, which could be very broad. For example, you may, in a power of attorney dispute, also be seeking guardianship, but your client might not seriously need to follow through on that to resolve the proceeding. So if your settlement option doesn't require the incapable person to, say, be bound by it or even necessarily be involved with it, um, you may not need to really dig into that. Are they a party under disability um, issue as deeply? So know your pleading, know the issues that are in dispute, and then also know when you're talking about negotiating with the other parties, what are the issues that we're really negotiating on? Because, I'm not, as much as I want people to have their rights to be involved when they want to be involved, and I mean people who have some diminished capacity. I don't want to drag someone with diminished capacity into a feud that really has nothing to do with them. Maybe it's among siblings or other beneficiaries or what have you. I only want to drag them into litigation if they need to be dragged into litigation. Um, so when a person with the diminished capacity has a lawyer, that's super helpful because lawyers are supposed to be confirming their instructions that they're getting are capable instructions. That's a great benefit to other parties when that person is represented. Unrepresented people, we got to think through really, do we need to bind this incapable person to our settlement agreement? Because if they need to be bound to the settlement agreement, then we got to tackle this issue of, are they a party under disability or not? And, everybody may know it, but we may not have evidence of it. So that's part of that struggle of digging into that issue. Um, so if your settlement is just amongst the capable parties, um, for example, a settlement that just restores the status quo. So somebody started an application, say to challenge a power of attorney, um, and then the settlement is, I'm going to withdraw or abandon that application because I don't know, they got something else that they wanted or they realized their case was going nowhere. Um, it just restores the status quo. That power of attorney that was in place is still in place. That's an example where I would really be trying to consider, can we do this without binding the incapable person? But if we need that incapable person to be bound, say, there's going to be some change to a power of attorney or some right that they have to claim money is being waived or compromised, or even just losing out on their right to seek costs in this litigation, I think it's really important that we get them bound as well. Another reason that we want to be thinking through these things really early on is because we want to know who we're negotiating with. Are we negotiating with all the right people? And, if it turns out that some settlement option that we have our heart set on is going to require the potentially incapable person to be bound by it, then we want to know, are we negotiating with them? Do they have counsel? And if they are a person under disability, then they need a litigation guardian in most cases. Now, Jake mentioned the exception to the requirement for a litigation guardian, which is for guardianship proceedings under the Substitute Decisions Act. It's, I think, important to note that it just says guardianship. It's in that section. So all kinds of other proceedings under the Substitute Decisions Act sort of do not have that exception for the requirement of a litigation guardian. But also litigation guardians could be appointed in guardianship applications. They're just not required necessarily. And there's a test worked out in the case law over whether that should happen. It seems pretty open-ended for now, so argue what you want about that for now. But if you do determine that there is a litigation guardian necessary because of the issues that are in dispute or the settlement options you want to explore, first of all, litigation guardians are required to be represented by counsel. Super helpful. They're required to be free of any conflicts with the incapable person. And there's certainly debates over whether somebody should be a litigation guardian or not in that area. They have a mandate. They're supposed to be acting in the capable person's best interests. And the litigation guardian can do anything in the proceeding that the person can do. And so that's what they're supposed to be doing. So that means they can sign minutes of settlement. They can agree to resolve claims that have been made or are available in the dispute. Like, for example, litigation guardians are supposed to start cross claims, counterclaims, third-party claims, if they have to. And they can sign on behalf of the party under disability. So they're not signing in their personal capacity a settlement agreement. They're binding the incapable person subject to court approval. So that means you don't have to run off and get a signature from the person under disability. They get a break from all that negotiation and resolution discussion. Now, we had a bit of a debate with our panel in our planning call over whether litigation guardians can sign releases without the LG also being a guardian of property or attorney for property. I don't think we came to an answer on that. I think it's an open question. I'll just say, don't presume that they can. Maybe turn your mind to it when you're negotiating with other people. I'm quite sure the children's lawyer and PGT routinely say no to signing releases. Children's lawyer often because they're not guardian. Even when PGT is guardian, they often will say no, we're not going to bind heirs of this person to this agreement. We're just agreeing to end this litigation. So that's something to keep in mind when you're drafting the nuts and bolts of your settlement agreement when there's a litigation guardian involved. The litigation guardian typically brings the motion for settlement approval. I say typically because my rereading of the rules, I don't think they have to. I think any party could bring it. If you're in one of those guardianship application situations, well, then any party could bring it. And any party steps into the shoes of the litigation guardian. Often it's the person who is the substitute decision maker, say the guardian or the attorney for property who does it. They have to file the material in support from them and from their lawyer in support of the settlement approval. Now, just in that guardianship situation, again, just be very careful on, is this purely a guardianship application or are there other issues? I know a ton of guardianship applications also throw in fiduciary accounting and maybe trust claims, all sorts of claims that are not purely uh, guardianship requests. And we've included in the set of material for today an endorsement, an unreported endorsement in the Han and Han case, where Justice Sanfilippo went through the analysis of, was a litigation guardian required for that proceeding, and it really turned on that question: are there other issues? Are there other issues in the proceeding, in the settlement, that are not just guardianship? Now, sticking with the guardianship situation or the Substitute Decisions Act situation, where Section 3 counsel is involved, I hope everybody is comfortable with the idea that Section 3 counsel is not a litigation guardian. Um, Maybe for the non-estate litigators, I'll just mention Section 3 counsel is counsel appointed for an allegedly incapable person in a Substitute Decisions Act proceeding. Well, who doesn't have counsel of their own? So I wouldn't expect Section 3 counsel to sign any minutes of settlement, personally. Um, Certainly they can. Section 3 counsel is counsel, so any lawyer can bind their client, but they should be doing it when they have capable instructions from their client to do so. And also, they can't negotiate things that their client is incapable of agreeing to. So, for example, some people try to negotiate, well, the person will just do a new power of attorney for property, appointing different people or under different terms or such. Um, if the Section 3 counsel's client is not capable of granting a power of attorney, well, then they can't really negotiate that. If the person's incapable of managing property, well, Section 3 counsel can't really negotiate a cost compromise or a payment of other people's costs from the incapable person's funds. Um, and the Section 3 lawyer should be clear on what they have instructions on and what they don't. You may have to read between the lines because they're not supposed to be sharing their opinion on their client's capacity, but they should be clear with the people they're negotiating with on what they have instructions to deal with and what they don't. Again, these issues should be canvassed really early on, because if you need a Section 3 lawyer to, say, establish the allegedly incapable person's wishes, maybe that's relevant to your issues in dispute. You want that person in there early on so that when you're negotiating, you have those important pieces of information. It might be wishes, it might be positions on who should be making substitute decisions in the future or not, or do they want a capacity assessment? Like, you might need to know all these things to really understand and think through what are the settlement options that we can work with. Now, I don't try to, as I said, I don't try to involve, say people with dementia or other cognitive issues in disputes that they don't have to be involved in. So sometimes I try not to press this issue, because pressing that issue is going to require maybe a motion to order a capacity assessment so we have a clear answer. But in my experience, the judges are sensitive to the not wanting to bother people when, say, for example, it's a sibling dispute or there's some other dispute among more active parties. Um, so I think there's some flexibility in the approach you take, but it's really benefits from thinking through start to finish how the issues you've raised can be negotiated and what's open, and having the discussions with your client, what's open to your client or not in terms of settlement things that they want to consider. And that will help you map out a plan over when you need to, if you need to tackle this question of capacity of a party that's really unclear. Lots more in the material. Like I said, we couldn't get into it all. That's all I really wanted to cover today, subject to questions. So I'll turn it over to Brendan.
Thanks a lot, Alex. I agree 100% with Alex when he points out that you need to treat these approval processes not as an afterthought. You don't just sort of, okay, well, we settled now, and so somebody will get approval, Bob's your uncle, and then we're all fine. You have to think about it as from the very start, you have to determine whether or not you think you're going to need settlement approval at one point, because that really guides you in what you're able to do. I mean, it doesn't make sense for people to be exchanging offers that will never receive court approval. Alex and I actually had a case where some self-represented parties came up with a settlement all on their own and everybody signed, but it was a terrible settlement for their incapable mother. And it was just bad. And you know, lawyers can't go into negotiations that will result in a settlement that there's just no way it's going to be approved. So you should turn your mind in advance to what is going to be needed in order to get approval, and you should turn your mind, as Jake pointed out, turn your mind in advance to all of those gray areas where, well, are we going to need settlement approval? If this is a fight between two co-attorneys and they end up agreeing on, okay, well, this is what we'll do, is that something that's going to need settlement approval? I have one case right now where there's an unborn interest, and that may be born at one point, and so we need to determine whether or not we're going to need court approval. So you need to build in that process into your settlement offers. Who is going to bring the motion for approval, and you need to bring, and who's going to pay the cost for the motion. And you also need to build it into your offers potentially if you're going to make a settlement offer and you know that issue is out there. Who is going to be the litigation guardian? Does the litigation guardian have a pecuniary interest that's going to make it difficult to get court approval? Do we need a guardianship order at the same time? So and if you're going to be at judicial mediation, will you be able to get some of this accomplished right then and there? I would say probably not, but I've heard legends that some judges will just approve the settlement that you reach at a judicial mediation. So I agree with everything that's been said. I want to speak now about the nuts and bolts because it's the really fun part. So read Rule 7.08 of the Rules of Civil Procedure. It provides you with the code, but not the complete code for what you have to do. It sets out, for example, the scope. It explains that the approval process is required for actions and applications. It's the same for judgments on consent, and it's the same even if no proceeding has been commenced. So sometimes we go into these sort of early settlement negotiations, and then it turns out, oh, you know what? We think we're going to need approval, even though nobody's commenced a claim. We're still going to need some form of approval to explain what has gone on. The rules actually set out the materials that are to be included as well. 7.08 sub 4 sets out that you need an affidavit from the litigation guardian explaining the settlement, and you also need an affidavit from the lawyer acting for the litigation guardian setting out the lawyer's position regarding settlement. And I'll talk about those affidavits and what they need to contain. If there's a minor over 16 years of age, the minor's consent in writing. Sometimes the minor will not consent. Sometimes the minor does not agree to the settlement, and that needs to be dealt with in court. The copy of the proposed minutes of settlement. And then under Rule 4.1, 4.2, 4.3, and 4.4, they have these provisions that relate to the information that is actually put before the court, because some of it is going to be privileged. And so some of it can be redacted, and then much like a motion to get off the record. I don't know if you've brought motions to get off the record. You send the materials to the court separately. So there's the unredacted materials that get sent to the judge in one fashion, and then there's the redacted materials that get put up on Case Center. And the reason why this is built into the rules is because oftentimes the affidavits that describe the settlement will contain privileged information, will contain information about about the incapable person, their health situation, and the strengths and weaknesses of the case. which may be something that shouldn't be brought into open court. In the event that somebody then later tries to cite it or rely on it, you have to imagine what happens if the settlement just gets rejected. What if the court just says, no, I don't believe this is in the interests of the incapable person? Well, then it's a good thing that that those materials were redacted, and or there's been some sort of seal. So in addition to Rule 7.08 of the Rules of Civil Procedure, you should take a look at the practice directions. In Toronto, we have the consolidated practice direction, and there's a sub rule within it, or section, I guess you call it, section 10. Rule 7 applications, Rule 7 motions, and other applications and motions in writing that are proceeding on consent of all parties may be brought as follows. And they talk about the process, like the actual nuts and bolts for how you do, they have to be searchable PDFs. We all know how to do this now. Sent into the Civil Submissions online portal and then uploaded onto Case Center. However, where there's a sealing or redaction orders requested, the redacted and unredacted materials are to be filed simultaneously. Redacted materials are to be filed through the CSO portal. Unredacted materials must be emailed to the trial coordinator's office at, they give you the trial coordinator's email address, clearly indicating that a sealing or redaction order is being requested, and then unredacted materials that are subject to this that are being emailed should not be uploaded onto Case Center. So you will have your unredacted materials before the court, but not on Case Center. So not everyone's going to be able to take a look at them. There's some other details as well in that practice direction, including at the end, they direct you to go to another page, which is accessible online, which is the best practices guidelines and checklist, which you can find using Google, or you can take a look at the paper that Jake prepared and Alex also prepared a little bit. But it's there's all the resources are contained in the footnotes there. Best practices in the checklist. It's a good read through. It's a reminder of all the things that need to be contained in the affidavits. I think sometimes people assume that when they put in these affidavits that the court is going to pay a considerable amount of deference to the LG, the litigation guardian that is, and to the lawyer. I don't think that's the case. I don't think a lawyer can just say, having in mind all these different factors, I consider this to be a reasonable settlement, having regard to the risks of going forward and the potential legal costs of fighting over this joint account or whatever it may be. The court isn't just going to accept at face value someone's affidavit saying, I think this is fair. So in the best practices guidelines and checklist, they say that the motion record needs to contain the pleadings, the sworn affidavit of the litigation guardian, sworn affidavit of the solicitor, a copy of the signed consent of the minors over the age of 16, a copy of any applicable contingency fee agreement or other fee arrangement. So if the fees are going to be a big issue preventing approval, which they can be, then you might have to put in the various agreements relating to fees, the executed minutes of settlement, and of course a draft approved judgment. The affidavit of the litigation guardian can speak to the benefits that the incapable person is expected to receive. This can be very complicated because it's not just a pure mathematical exercise. It's not just to say, well, if we won, he or she would get X dollars, and if we lost, then he or she might have to pay costs. And so I think on balance, this is a good sort of number. Oftentimes there are intangible things in there as well, such as where is the incapable person going to live? Is the incapable person going to be able to live at his or her home as opposed to being forced to go elsewhere? Sometimes these issues are in the litigation, and they need to be spoken to by the litigation guardian. And the litigation guardian is well placed, hopefully, to be able to speak to that. Bear in mind that the litigation guardian, and Jake pointed this out, the litigation guardian should not have some kind of conflict of interest or pecuniary interest in the settlement. I'm aware of one case where the application for approval got rejected because the judge pointed out, well, the litigation guardian here is also a beneficiary. And so this litigation guardian isn't entirely neutral because the settlement benefits him or her. So you have to be careful about that. And then in the affidavit of the lawyer, this checklist actually provides a pretty significant guidance. I'll read it. This is a document that explains why the proposed settlement ought to be approved by the court. In this affidavit, counsel must set out the theory of the plaintiff's case and include expert reports supporting the theory both on liability and damages. It must detail the reasons counsel is of the view that the proposed settlement is advantageous to the party under disability as opposed to proceeding to trial. And it goes on. So in some ways, this affidavit can be a very bulky document. It's not just a, just short 10-paragraph affidavit. It can be a very bulky document that looks into the evidence, that looks into the risk. And it can be a very jarring experience if you're counsel and you're now having to sort of switch hats. You're no longer just being a zealous advocate saying, I will win. You have to actually present the weaknesses, warts and all, of the client's case to say, actually, there's an issue here. Actually, a court might consider this piece of evidence is actually very bad for this person. And so you're switching into a almost a quasi-adjudicative role where you're trying to sort of say to the court, having regard to all these factors, this is a good settlement. And expose the weaknesses in potentially your side. I have a case actually where the parties agreed on minutes of settlement, but then when the person who brought the motion for approval put in his affidavit, there was a bunch of objectionable things in the affidavit. And so one of the other parties began fighting him on that affidavit, leading to a sub battle. Now, I don't think that that's very common. It should be rare. But I raise it to emphasize how the approval materials need to be very carefully drafted. You need to be able to persuade a judge that the settlement is good, which can include an analysis of the strengths and weaknesses of the case, the evidence, the case law, and a lot of other intangible factors, not just risk, but what is the incapable person getting out of it in terms of, where will he or she be living? And, is this person going to be close to them? Even little things like, well, they'll be able to continue living here, which is close to Aunt Patty or something like that. So I once had a judge say to me on an approval motion, this is what I would have ordered anyway, which I took to be a compliment, but also really shows you the amount of evidence that you have to put before the judge in order for the judge to be able to make that determination that, yes, this is within the realm of what ought to have occurred if it went to trial. And yes, I agree, this is a better result than having to go to trial just to achieve something like this. So I think I've gone through most of what I wanted to say on the nuts and bolts. And so with that, I guess I'll open it back up to Peter. Thanks.
Thank you very much, Brendan, and Alex and Jake. Thank you very much for those presentations. They were excellent. I'm going to open the floor now to anyone who might have a question about what we've heard today. There is one question that was posted in the chat. I've distilled it down. I don't think we need to get into the whole fact scenario of it, but essentially the abridged version is there's a power of attorney dispute. One sibling says this power of attorney is valid. The other brother says their power of attorney is valid. This is over their father. It's an open question as to whether the father has capacity, but he is declining. And so the question is, do you need to involve him or is settlement approval required in this situation, that there's just these power of attorney disputes happening? And it is an open question as to whether this father is incapable.
Guess I'll take a crack at it. In situations like this, I like to go back to who has an onus to prove what. So if you've got a more recent power of attorney that appears to be valid on its face, subject to what's written in it, it's going to revoke prior ones. So I think if your settlement isn't going to change that, if it's going to go back to that legal status quo, I don't think you need settlement approval. But if you're making changes to it, then yeah, you would. if the person's a person under disability. Right?
I have something I might add to that if I could, which is it sometimes you want to have to avoid the additional cost and expense of doing an approval motion. That's a completely valid thing to try to do, especially if you can if you can achieve it. Sometimes it's the other direction. If you're representing trustees, say, and they don't know whether this person is capable or not, maybe you want to insist on getting an order, not only approving the settlement but also implementing the settlement, like directing the trustees to do this so that they can say, we abided by the court order. Sometimes one or more parties might want to get that order approving the settlement just to have that level of comfort. But that won't apply in all cases.
Yeah, I totally agree. And there are some things that people try to squeeze in that are, I think, potentially against public policy. Like, for example, um, I'm binding myself as a substitute decision maker to future decisions. Like saying I will never move dad from his house or something like that, or I'll never bring another guardianship application. I'm not sure that's actually feasible because situations can change and fiduciaries like substitute decision makers have to make decisions based on, the facts and situation applicable at the time. So there may be time that there needs to be another guardianship application. Um, so that's just sort of a something to flag when you're thinking through the scope of what somebody is agreeing to give up in their litigation.
Right, I've got another question here from one of the attendees. They reference a 2020 decision. It's called Dawson and Dawson. And they note that at paragraph 13 of that decision, the judge points out that the opening words of Rule 7.01 explicitly give the court discretion to deviate from the general rule that a proceeding shall be commenced, continued, or defended on behalf of a party under a disability by an LG. Is that position generally accepted, and how might that impact a Rule 7 approval? Anyone want to take a stab at that?
I think you're taking your chances either way, and you got to assess the risk. Like there's a chance that somebody's a party, maybe some litigation involves them, and they might be a person under disability. And if you're willing to accept the risk, or I should say, if your client's willing to accept the risk that the deal comes undone if it's unveiled later that they were under disability at the time, so they're not bound by it. Some people can accept that risk. But if you're thinking, well, the person is under disability, you're going for your approval, you're kind of taking your chances, or you're going for, say, a judgment. You're kind of taking your chances that the judge is not going to stand up and say, well, I have questions now about whether this person is a person under disability and requires an LG for this settlement, which I don't think we can easily get, at least in our current rules, under our current rules of civil procedure. I don't think we can get an easy answer on that, other than to decide on the approach we all want to take and to take it, or take a stab at it.
Thanks for that. I'm going to raise one question. Brendan, in your part of the presentation, you were talking about the counsel affidavit that is needed for a settlement approval and kind of showing the warts and all of your client's case to, not necessarily persuade the court, but to be transparent to the court about some of the risks that are involved. Strategically, how hard do you think counsel should be going on that? Because it's a balancing act of you don't know if you're going to get court approval. So what happens if You talk about how terrible your client's case is in an affidavit that you swear. And then the court says, no, we're going to take this to a trial. What, do you think that that raises a concern that that affidavit could be used against you, or perhaps do you think that that would fall under redactions that are permitted?
I mean, instinctively, I don't like to say really negative things about my client's case. I think we all probably have that same instinct. It's often possible, in my experience, to talk about just possibility. Just you don't have to point out something that has not already been disclosed and say, like, by the way, my client is also going to be a terrible, terrible witness, right? Or by the way, we haven't disclosed that actually this person has an illness that's really going to affect something, right? Like you don't necessarily have to go and do that. You can point out, I think, without too much difficulty that there's a conflict in the evidence. This person says this person says this. In order to resolve this issue, which turns on credibility, there would need to be a trial, and I estimate that the trial would take at least 3 days. I mean, what trial can be done in less than 3 days on an SDA type issue? It's going to take, you can count out the number of witnesses or people who've sworn affidavits, and I anticipate that it's gonna cost this much, and a lot of people are going to be seeking their costs payable out of the incapable person's funds. I mean, that's almost always a factor. And you can put that in front of the court and say, given that this is not a sure thing, and given that there are going to be a lot of cost claims and it's going to take a trial of many days to resolve, in light of all those things, in light of these risks, here's what the evidence says, this would need to be dealt with at court. This is a good settlement. And how far you have to go depends on how good the settlement is for the incapable person or not. I mean, I don't think it's enough to just say, oh, it's going to cost money to resolve, so just accept it. That's not good practice. But I think you can draw attention to the risks without really doing a hatchet job on the case and saying, oh, there's a bunch of really bad stuff that hasn't been disclosed yet that's definitely going to come out and it's going to look awful. So I would use your judgment, but try to balance it. Try to say, okay, this is how much I'm going to need to disclose in order to make this settlement really palatable to a court.
All right. Thanks for that, Brendan. And again, thank you to all our presenters today and to everyone who attended. We're going to conclude the seminar now. I see that it's 1 p.m. Please remember that the certificate of attendance is found in the chat. We're looking forward to seeing you at our next seminar. It's on power of attorney issues. That will be on October 21st. It was originally scheduled for October 23rd. It will now be taking place on October 21st. So make note of that. And that will be chaired by Brad Phillips, Yana Fox, and Lisa Assad. If you haven't registered yet, you can do so at the link posted in the chat. And again, a final reminder, the link to the B'nai B'rith Canada can also be found in the chat in case you would like to donate. Thank you again to everybody, and enjoy the rest of your Tuesday.